Hi, my name is Diane Weinberg, and I'm the principal of Weinberg Elder Law located in Sandy Springs, Georgia. And I'm bringing you this video today as part of our celebration of May as National Elder Law Month. We're taking a full week to talk to you about some of the more common issues we see in our firm. Now, one of the most common issues or common questions that we get is about guardianships and conservatorships and how they differ from powers of attorney. Now, I do want to note at the outset that terms for guardianship and conservatorship are going to vary from state to state, as well as the powers of attorney. So make sure that this is applicable to where you live. Now, guardianships and conservatorships are processes by which a court actually removes an individual's fundamental rights. In many respects, it's equivalent to a criminal process where, just like somebody's convicted of a crime, they lose their freedom to move around. Well, here, no one's convicted of a crime. The standard in Georgia is that they lack capacity to make or communicate significant responsible decisions with respect to their health and safety. So simply, or with respect to the management of their financial affairs. So by simply having a disability that impacts your cognitive impairment, you haven't done anything wrong, you've just developed a disability, this is a reason that a court might remove your fundamental rights or the fundamental rights of a loved one. Now, guardianship deals with those rights that are personal to our person. So it involves the removal of rights, for example, medical consent, marriage, where to live. Those are all rights that can be removed in a guardianship. Now, a conservatorship, by contrast, deals with financial rights. The ability to buy and sell property, to manage your finances, to enter into business or commercial transaction. Now, both processes remove your right to sign a contract as well as your right to sue. By contrast, a power of attorney, an advance directive for healthcare, those are the terms used in Georgia. The financial power of attorney, as it sounds, manages finances. The advance directive for healthcare directs somebody to act on your behalf with respect to medical processes. Again, this will change from state to state, or the term will change from state to state. This gives somebody the ability to do something that you can do yourself. So I can write a check on my bank account, and I can give my agent under a power of attorney to write a check on my bank account. I haven't given up my right to write that check. I'm just allowing somebody to do the same thing that I can do. And as long as I have capacity, or as long as I satisfy the standards in the statute, I can revoke that power of attorney. So somebody can be my agent today. I don't like how they're acting with respect to my finances, and so I'm going to remove them as my agent. There's no court involvement with a power of attorney, but you do need capacity to sign the documents. So that's very important. You need, again, so the difference between a guardianship and conservatorship and a power of attorney or advance directive for healthcare, again, one is a court process involving removal of somebody's fundamental rights, and the other is a document that allows somebody to do the same things that you can do, but you remain in control. And if you don't like how they are executing their responsibilities, you can always revoke them as your agents. Again, this is Diane Weinberg with Weinberg Elder Law, and thank you very much for spending these few minutes with me. Have a wonderful day.